All right, today's Tuesday, March 15th. It's about 6:45. We have 8 bills on the voting list. We're going to start off with Senate Bill 750, and that's Josh.
Senate Bill 750 amends the Baltimore City Charter to authorize the city to tow vehicles blocking access to driveways, alleys, transit lanes, or parking facilities.
We have a delegation letter.
Yeah, we do.
We've got a delegation letter. How do you feel about this towing bill, Senator Carter? Senator Sidnor? Yeah, we do. Awesome, thanks. All right.
Charles has from Sandy Brantley saying that it would be constitutional for us to amend the city charter.
That was one of the questions that we had, so I reached out and she said we could do it.
So, I mean, I don't want to waste time on this because it's interesting because when we did for the police department, we had to amend the city charter, it has to go to a referendum. Like, they have to vote on it.
Yeah, so why doesn't this?
Go ahead, Josh knows, sorry.
Her email, it said, the General Assembly may amend Article 2 to grant Baltimore City additional express powers.
Yeah, so the provision, and I'm not the expert on it, but the provision making the Baltimore City Police Department instrumentality of the state is actually in their public local laws, not the charter. I think that's the distinction.
So we can amend their public local laws?
Yeah, but I think we may need to get a reference. This is to the charter. We can amend their express powers.
That issue came up with the civilian review board, and we can.
Got it. All right. There's been a motion for favorable, it's been seconded, is everyone okay? All right. We'll go on to Senator Waldstreicher with Senate Bill 878.
Senate Bill 878 modifies procedures under the Maryland Trust Act that a trustee may elect to follow upon the termination of a trust or the trustee's removal or resignation to seek the trustee's release from liability for the administration of the trust. The bill modifies those procedures by allowing a trustee to seek release from liability for one or more interested parties rather than from each interested party individually, by allowing for earlier distribution of trust assets if the interested parties from whom the release from liability is sought each submit a written statement that they do not object, and it limits the interested parties who must be involved in resolving an objection to those from whom the trustee seeks to release from liability.
Questions? Senator Carter.
Senator Waldstreicher, can you just refresh my memory? Who wanted this bill and why do we need it?
Yeah. So the Maryland Bankers Association represents trustees, in other words, people who administer trusts on behalf of beneficiaries. A while ago, we passed a bill that says when the trust ends and the assets are distributed, after 120 days, if no one objects, the beneficiaries can receive the assets of the trust. What the issue is that all the beneficiaries could agree that the assets should be distributed, but they still have to wait the 120 days. So this says the 120-day rule still applies, but if all the beneficiaries assent to the distribution of the assets prior to the 120 days, then the trustee can provide the assets to the beneficiaries.
For favorable, it's been seconded. Further discussion? All right, is everyone okay? All right. All right, we're going to go to Heather with Senate Bill 820.
So with Senate Bill 820, there are 2 amendments in your packet. Both of these amendments are from the sponsor. So the amendment ending in 24, this sunsets the entire bill, including the other amendment, in 5 years. The other amendment ending in 26. So this bill, as amended, requires DHS to implement policies to ensure that if a local department or law enforcement agency fails to see a child after receiving a report of suspected child abuse or neglect within the current statutory timeframes, the reason for the delay is documented and the supervisor at the local department is made aware of the delay. The bill requires DHS to prepare a quarterly report on the investigations and reports that are not completed within the statutory timeframes. The bill also requires DHS to assess certain studies related to workloads and child welfare systems, make a report on best practices, and compare its current practices to the best practices in the report developed by DHS.
I had a question on this language.
Yes.
On the last page, why is there stuff, the Colorado Child Welfare County workload, the Alaska Department of Health, Human Services? What is all this language in the back?
Yeah, so you are looking at page 8 of the reprint and the unnumbered page of the reprint. So this is part of the uncodified amendment language. So on or before December 1st of 2023, DHS is required to analyze these studies related to workloads and child welfare systems, and it lists out those specific studies that they should review. And then this is the report that they will make on to develop a best practice plan.
I mean, my question on that is, if he wants them to review those studies, the sponsor, he can write a letter to them and ask them to review those. I don't feel comfortable because I'm unfamiliar with the Colorado Child Welfare or the Alaska Department of, the workload report to the 79th Legislative Assembly of Oregon. I'm totally unfamiliar with these, so I'm not comfortable with that part, even though it's uncodified, because I don't know what these are, and that seems like something that you could simply write a letter and ask them to study those.
So if you wanted to do that, I would strike the 1 through 4. Oh, there's actually a typo there. It should be 1 through 5. And just say assess studies and methodologies related to analyzing workloads and child welfare systems, and strike the specific ones.
Yeah, I would move to strike,
Do we happen to know if these are the things that were specified in the audit report?
I do not know, that was not conveyed.
We could look that up easily enough. I'll look that up. Because if that's something that's being suggested by OLA, then
Strike. So you're just gonna say assess not the following studies. Can you give me the language again? You would say,
So assess studies and methodologies related to analyzing workloads and child welfare systems,
period, no colon, strike everything else.
Correct.
What lines are she,
It's not line because it's on the last page, but
the whole last?
it's Roman numeral 1 through 4.
Oh, Senator Heddleman, I'm looking at the I'm assuming this is the correct one. It's the audit report, Department of Human Services, Social Services Administration, dated June 2021. I just did a quick control find for some of the terms listed in here, and they did not appear.
All right, so Senator's made a motion to strike. It's been seconded. Everyone's good. All right. Now the bill's before you as amended.
So yes, there's two amendments.
Oh, sorry, you're right.
So we,
So then, this amendment's adopted, but then you've got the amendment. Here, I can show you the page number. You want to explain the second amendment?
Yeah. So. There's two.
This thing's got three amendments. Three total with the one Hub added.
right.
Two, one you have not talked about yet.
So the other one is a sunset amendment it'll sunset the entire bill, including the amendment, within 5 years, or in 5 years.
Is everyone okay with that?
Yes.
Are you good with the third?
Yeah.
Okay. All right, now the bill's before you with the amendments. The motion is for favorable.
Second.
Is everyone okay?
Yeah.
All right, I'm gonna go to. So Senate Bill 599.
Senate Bill 599 authorizes the Motor Vehicle Administration to allow a licensed driver school to administer the driver skills examination for non-commercial driver's licenses. The bill further establishes various standards and requirements for both the driving schools and the individuals administering the skills examination. A participating school may administer the examination only if, among other requirements, it has entered into a memorandum of understanding with the MVA that has not been terminated by either party.
Now you're gonna do Ed's driver's school that you pay is gonna do your driver's test versus the MVA where you show up and like have a police officer sit with you and drive you around. I had a police officer do mine with me.
Oh, yeah?
I guess I'm old. I'm sorry. I don't know. They have MVA employees do it with you
Yeah,
now?
it's like an employee. Hold on. Yeah.
I don't believe it's necessarily a police officer. Exam as an MVA instructor. They do advise that it's possible that there could be a potential significant fiscal impact depending on how many schools are authorized to administer the exam because they will have to conduct oversight of those schools. And they also note that certain issues are not addressed in the legislation, like, whether they could pay certain fees at the driver's school or whether they have to go back to the MVA. Those things would presumably have to be addressed by either the memorandum of understanding or the MVA would promulgate regulations on those.
Could you put the, mic, sorry. Could you put the mic to your, sorry. So everyone can hear. Go ahead.
Oh, okay. Is this like privatizing a public service? Oh, okay.
Yeah, the
I
private
don't
driving
like
schools
that.
would be authorized if they had an MOU with the MVA to conduct the service themselves.
To be clear, it's not shifting the responsibility, it's offering, it's expanded, yes. So it's the MVA still gonna be responsible for doing this, it's still gonna be responsible for the oversight, you just have to enter into an MOU, in order to do this. That's the testimony.
So if you remember the testimony, that's exactly what happened. And we've got this in our area. Class B licenses, I can't get driving for the people to drive the fire trucks. They can't go to MVA to get a test. They only allow one test, every 3 or 4 months for those people because they're so overbooked. And, I had a daughter that during the pandemic, she turned 16, so we got her driver's license. Some of those kids that waited, like they normally did, waited an additional 6 months to get their driver's licenses. So this does not take it away from MVA. This just gives people another opportunity right, with the long delays that exist, and they can actually pay for it if they want to.
As a person who spent much of my life being petrified at the MVA, having horrific traumatic experiences every time I had to go there for any reason, I resent the idea that people wouldn't have to also suffer that trauma.
Gotta get your number.
But anyway, no problem really. But seriously, like MVA is like treacherous. No matter what you do, you never have it all right and all together when you go there. So.
We've all got our MVA horror stories. She wants everyone to get hazed. All right. Senator, let's go to Senator Sidnor and then Senator West.
I'd be, I guess, more comfortable if we said something within the bill that the MVA was going to promulgate, or that the Department of Transportation is going to promulgate regulations rather than leaving it up to an MOU. I mean, that way everybody knows that they're entering something on the same level and under the same rules, right?
So I believe current law would certainly authorize them to promulgate regulations, but if you wanted to create language that said they shall promulgate regulations, that would be kind of belt and suspenders, I think.
Make that motion.
There's an amendment to require the MVA to promulgate regulations when the MOU attaches.
Well, they're gonna have to anyways.
Yeah.
That's not, they're gonna have to.
Should we not wait for that before we pass the bill?
I would imagine they'd have to anyways, would they not?
Why would they, that's what I'm saying, why would they have to? If
I
we're
have
not
no,
tell-
I
if we're
have
not
no
telling them
idea.
to.
I mean, it says in their informational note, they're gonna have to have additional staff. So clearly, they're gonna have to set up a regulatory framework. That's why I'm saying, I don't know how this works, because apparently you have an MVA person with you now. When I did it, you had a police officer sit with you. But you go in the back, I know in Frederick County, you go and they have the course, you drive it and all that. You get an MVA person sign off. I'm just not comfortable with a driver school that you're paying money to. They're not really impartial.
So they're not gonna be failing a lot of people, is what you're saying? Because they want the business.
I mean, this is a weird position. I'm taking the anti-free market privatization position, but I just don't know how impartial they are. I mean, they already got rid of the parallel parking at the MVA. They did. You don't parallel park anymore.
No.
Now, I know the MVA had problems because of COVID, but I think they're getting through that now. I don't know how much issues there are. I'm not getting complaints from people in my district that they can't get in the MVA anymore.
Next, I'm gonna get rid of it exam. Have a bunch of
Senator West, sorry, go ahead.
Thank you, Mr. Chair. I don't have any problem with the driving school giving the written test. I do have some reservations about the driving test. For example, there's always a stop sign out there. So I can imagine the student driving along and going right through the stop sign, and the instructor said, oh, wait a minute, you went through the stop sign. Why don't you go around? We'll do it again, and this time I bet you'll see the stop sign.
No way.
Well, you know, this is an organization that was paid money to teach driving, and they don't want to flunk their pupils. And with the MVA, that wouldn't happen. But I'm worried that in a private driving school, that kind of thing could happen.
Susan, this is not privatizing things. just so you know, it's not privatizing driving tests. It's not privatizing. Go ahead, Senator Lee.
But aren't you taking a public service and contracting it out to a private entity?
Correct, but the public service also still provides the service. In the same manner in instruction, so it's not.
Totally fair. fact that they're receiving money from the student will have no impact on the driver's test.
But it's not privatizing.
Can I check with the lady with the,
Oh my God, all right. Good. Senator Lee's got the floor.
can I check with, I like to check with some individuals, like labor or something, how, if they would regard it as privatization. And also, I just want some clarity, make sure it's not privatization of a public service. Is that okay? I don't mean to hold it, Bill, but I just want to be clear about that. Okay,
Senator got to hold for a day.
thank you.
Are you voting on this amendment?
No. What amendment?
To make, if you pass the bill, to require MDL.
Senate Bill 581.
Just pull that up. Senate Bill 581 requires the Maryland Police Training and Standards Commission to develop a uniform citizen positive community feedback process to be adopted and followed by each law enforcement agency. The process must be simple and posted on MPTSC's website and on the website of each law enforcement agency that maintains a website. Each law enforcement agency must maintain a record of positive community feedback for all law enforcement officers within the agency. Notwithstanding any other provision of law, records of positive community feedback are subject to public inspection in accordance with the Public Information Act. There is one amendment in your voting packet, that is Amendment 433222. Oh, excuse me, that's the wrong amendment, wrong bill. Correct. So it's 133428/1. Essentially, this plugs in the record of positive community feedback, essentially in every place in the PIA where there's a reference to police disciplinary records that are accessible under PIA. So it puts it on parity with if something is just as disclosable that's a disciplinary record as it is for the positive community feedback.
What I would say about this is, we talked about this some last year, but I had some departments actually keep records to see how it would work, right? Out of their first 100, how did it work? How many were negative? How many were positive? And the feedback I got was right around 40% were positive, but depending on the department, there was nowhere that they could keep them. And we're definitely able to look at the negative, but this way they could look at the positive.
Just one quick question about the amendment, looking at bill page 2 of 2. I was curious, citizen complaint was struck and positive community feedback was put in. What is that doing?
New language, Senator, I noticed that too. I don't have any background on that. If I had to speculate, it might have been a drafting thing, but I'll defer to Senator Bailey on that. Right. So that's not amending current law. That's amending the new text of the bill.
Thank you.
Adopt the amendment. Second, it was good. All right. Motion, further discussion? Motion for a favor? Second? With amendment. Is everyone okay? All right, excellent. All right. We're going to go to Senate Bill 38, and then we are going to go to Senate Bill 691.
Senate Bill 38 requires a state or local fire and rescue entity that removes from duty a dog used in fire and rescue work to reimburse an individual who takes possession of the dog, as specified in the bill, for reasonable and necessary veterinary treatment provided to the dog.
The bill allows fire and rescue entities to accept donations to meet the bill's requirement and establish a separate fund as specified in the bill. The bill's provisions apply only to publicly owned dogs licensed by Department of State Police pursuant to provision in the public safety article. And with that, there is an amendment in your voting packet that actually makes a necessary technical correction to the bill. So that provision of the public safety article, which is Public Safety 2-313, those are registration for law enforcement dogs. Fire and rescue dogs are not registered under that section. So the bill as drafted wouldn't apply to any dogs or any fire and rescue dogs because of that. So what this does is it separates it out. So it's no longer referring to that provision of the public safety article.
Oh,
I'm curious, what's happened to this bill every year? Because we vote for it. Is the House not moving it?
No, it actually passed it was either 2020 or 2021. It's Chapter 90 of 2021 as it applied to law enforcement dogs.
Okay, so this is just added.
This is adding the
fire
fire
and
and
rescue.
rescue.
Okay.
The amendment first. Everyone's good with that? All right, this Senator West made a motion for favorable. It's been seconded. All right.
As the owner of a Dalmatian, I vote yes.
Yeah, there you go. All right. The bill passes with amendment.
Was he what? We're gonna try to figure that out now that this goes along.
There you go. So then he's gonna get some free health care.
We're gonna get he was, so yes.
All right, now we're on to Senate Bill 691 with Josh.
Do you want me to kind of pause? Senate Bill 691 makes numerous changes to the juvenile justice process in the state by generally implementing the recommendations of the Juvenile Justice Reform Council. So just kind of moving through the bill piece by piece. Starting on page 2, the first part of the bill deals with the jurisdiction of the juvenile court. So currently, there is no lower age limit on the juvenile court's jurisdiction. The bill would instead provide that the juvenile court does not have jurisdiction over children under the age of 10, and it does have jurisdiction over children ages 10, 11, or 12 who have committed an act which, if it was committed by an adult, would constitute the crimes of first-degree murder or attempted first-degree murder, first-degree rape or attempted first-degree rape, first-degree child abuse, sexual abuse of a minor, second-degree murder, armed carjacking, second-degree rape, a continuing course of abuse with a child, or a third-degree sex offense. And then quickly turning to page 5, the bill would additionally provide, children 13 or older, the juvenile court would have jurisdiction over any act. But quickly turning to page 5, the bill would provide that a child under the age of 13 may not be charged with a crime, meaning that they cannot be charged as an adult. Kind of the first part of the bill.
Come back later. Yeah, just keep going, and then we'll come back from the top. See you in a minute.
Keep going?
Yeah.
So then,
Yeah, absolutely.
So, no matter the offense, they cannot be charged as an adult?
correct.
Okay.
Absolutely. Senator Bailey.
Other crimes that 11 and 12-year-olds commit.
Currently, they would be potentially subject to being a child in need of supervision, but if it's not on that list of crimes in the bill, they could not be charged with a delinquent act for that act.
So I see down here, it says, like on E, on page 3, it says armed carjacking, right? just for my own clarification, we used to always have, if they attempted, right? So, I mean, so let's say they pull a gun out and they try to carjack the car, right? But the person hits the accelerator and they drive away, that would not satisfy?
No, because attempt crimes are not listed in there.
Well, I don't understand why attempt crimes wouldn't be in.
I can give you an idea why. So, first of all, let's backtrack a little bit and understand that this comes out of the work of the Bipartisan Juvenile Justice Reform Council, and all of these recommendations were supported unanimously. The reason that these chosen crimes were as listed is because they are currently deemed the most severe crimes by the Sentencing Commission. And so that's the reason that these crimes were done and not the attempt crimes. I also want to clear up what you said, Josh. Under current law, the crimes that you listed for the 13-year-olds and under, they can't be charged as adults now. Only 14 and up in Maryland can be charged as an adult. It's just the floor, not the ceiling. So under 13, they can't be charged in the juvenile system under this bill. They can only be subject to a SINS petition, which is children in need of supervision. And they'll then be able to avail themselves of all of the services within the juvenile system. But what will be absent is the actual prosecution in the juvenile system. Does that clear it up for you? So it's, this bill has nothing to do with charge as adult actually at all. It's only about being charged in the juvenile system or being charged through it, or being the subject of a SINS petition.
So can you say that first line again, about 14 jurisdictions? Say that one more time.
Under current law, the children under this bill, the 13-year-olds, they can't be charged as an adult. In Maryland, you can be charged an adult at 14 and up. But 13, you can't be charged as an adult now.
We're going to do back to Senator Bailey and Senator Watson. Are you done?
So I'm still back on this attempt, trying to just, I understand we had a group that did it, but attempted first-degree rape, where was that fall in here?
Well, that is in there because it's a crime punishable by life. So first-degree murder and first-degree rape, they have the attempt crimes folded in because of that.
Okay,
But it's attempted second-degree rape is not in.
but attempted second-degree is not.
Correct.
All right.
Senator Watson.
Help me out one more time. The armed carjacking. So literally just a couple weeks ago in Bowie, 3 young men tried to do a carjacking, and they were fended off because the driver of the car actually had a wear and carry permit and was able to fend them off. Now, you're telling me that the attempted carjacking, and they were all ultimately arrested, but the attempted carjacking, what happens to those folks?
That was never able to charge as an adult.
If they're 10,
It depends.
Bob Cassidy had that bill, it failed.
if they're 10 or 11, 12,
It
they
depends
can't.
the age, yeah. Under 13.
But
If they're 10, 11, and 12, they can't be brought to delinquency under your factual situation.
so if they actually got away with the carjacking, they would be able to be charged. If they attempted it, because somebody was able to defend their property, they could not be charged as an adult.
Under current law, they could be charged with the delinquent act in the juvenile court. With the bill, if they're 10, 11, or 12, if they only had the attempted armed carjacking, they could not be charged in the juvenile court with the delinquent act.
All right, thank you.
I would like referring to, if she's around, I don't know if she's around, but it's, in my practical experience, no one is charged ever with attempted armed carjacking. Even if the carjacking can't be proven, they'll be charged with the carjacking, and then it might, wind up that attempt is the thing that prevails. But they're not going to be simply charged with attempted armed carjacking. They're going to be charged with armed carjacking, attempted armed carjacking, and a myriad of other offenses. That's just the way that it works. But you don't have to take my word for it. I'm pretty sure I'm correct. I've never seen just a simple attempt charged. It's always the whole thing.
I can just count on that. We had a big fight in this committee. I can't remember if it was this term or last term, but it was the State's Attorneys Association wanted, that gets into this next bill, 165, to make it a mandatory, and it was attempted carjacking. The bill failed by 1 vote because it was a big push by the state's attorneys that year to add attempted carjacking, make it a mandatory charge as an adult. So obviously they are. I mean, the State's Attorneys Association, that was their big push one year.
I don't think that necessitates that they're charged with that. I think that that speaks to the fact that they couldn't maybe prove the carjacking, so they wanted to make sure that the attempt could fall under the same penalties as the carjacking. So I think that's more likely the scenario. I'm just saying, you don't get charged with attempt without the other thing. We're talking about charges.
So,
So just to kind of give some context, a child who would not be subject to the jurisdiction of the juvenile court could still be dealt with via a child in need of supervision referral, which generally requires that a state agency have to prove the facts by a preponderance of the evidence, and the child the court may issue orders to control although the child would not be able to be placed in detention, they could be placed in a shelter, and they could also not be placed in a facility that exclusively houses delinquent children or that houses adults.
Senator West, you have anything?
Move on.
We'll come back.
So moving on through the bill, the next portion of the bill deals with informal adjustment. So just to take a step back and give an overview of the general process of the juvenile justice system, the process begins with a complaint being filed, which is generally filed by a police officer it's always filed with a DJS intake officer who has 25 days to make a decision. Generally, their three options are to resolve the complaint at the intake process, to authorize the filing of a petition or a peace order with the juvenile court, or to propose informal adjustment, which is generally the provision of services in a non-judicial manner in order to address the problem. The services that can be provided with informal adjustment generally include referrals to other state agencies, orders that the child complete community service or attend counseling or substance abuse treatment or be supervised by DJS. So moving to page 5 of the bill, starting in line 29. Currently, the law requires that an intake officer who receives a complaint alleging a felony, or rather an act that would be a felony if committed by an adult, has to forward that complaint to the state's attorney. Moving on to page 6, the bill would create an exception to that if the intake officer proposes informal adjustment, the act did not involve the intentional causing or attempt to cause death or physical injury, and the act is not a crime of violence as defined in 14-101 of the criminal law article. Moving on to the bottom of page 6, an intake officer would now be required to propose informal adjustment if the child has not previously been adjudicated delinquent or proposed for informal adjustment. Adjudicated delinquent meaning that the case went to the juvenile court and essentially they were found the equivalent of guilty for the act. So it would require that. It would require that the act for which the complaint alleges would be a misdemeanor if committed by an adult, or a felony that does not involve the intentional causing or attempt to cause death or serious injury, and the act is not a crime of violence under 14-101. Moving on, the current law requires that an intake officer may not proceed with informal adjustment without giving notice to the victim of the crime. The bill would also allow informal adjustment to proceed without notice if the intake officer has made a reasonable effort to give notice. Additionally, Current law requires that informal adjustment cannot proceed unless the victim gives their consent. The bill would remove that requirement. And finally, the bill would create a procedure in juvenile court which is similar to a probation before judgment in adult court. It would allow the court, with the consent of the child and the state's attorney, to hold proceedings in abeyance, to proceed with informal adjustment. And if the child completed the informal adjustment, the charge would be dismissed. And like a PBJ, if the child failed to complete the informal adjustment, the case would proceed.
Senator Carter.
I think that a couple of things, going back to the issue of notice to the victim, what DJS has testified to for several years, even before this bill, because there's been bills to propose expanding informal adjustment, is that oftentimes the child is held up from getting services because they can't notify or they can't reach the victim, especially if the victim is like a store or a business or something like that, that they don't have any interest in it. So the other thing is that I think that it's less like a PBJ than a diversion program in adult court, where or like when you go into one of the specialty courts like drug treatment, and they offer to not prosecute the case as long as you comply with the conditions. So it's less like a PBJ and it's more like diversion or a conditional stat, sort of. It's a delay of the prosecution. If you comply, you won't be prosecuted. If you don't comply, then you're still prosecuted.
I just wanted to say I have a note from Senator Cassidy, who couldn't be here, and he believes this section gives too much power to the person who decides to go for an adjustment, and the state's attorney should have more involvement.
What page are you on?
I guess pages 7 and 8. What's the name of this person? The intake officer. Yeah, too much power to the intake officer and not enough power to the state's attorney. So the intake officer basically is given the power to make all these decisions, and the state's attorney is pretty much excluded. That was Bob's note. I'm not sure I agree with it, but that's Bob's note, and I want to report it to you.
Well, now that it's out there, what do you think?
Well, I was on the commission. I voted to go ahead. I voted basically for this language. And I stick with the vote I cast several months ago.
Conversations with DJS about the bill, and also what I recall we discussed in the commission meetings. I've stated this before, but I'll just restate it. This isn't a way to kind of get away from victims. And again, we're talking about misdemeanors and nonviolent acts that would be felonies if they were adult. Oftentimes, it's not possible to reach the victim. And so because of that inability to do it, they can't proceed with the informal adjustment or the diversion program. But there's nothing in this bill that would prevent a victim that felt strongly from going to the state's attorney and saying, no, I don't want this, I want my case prosecuted. This is just about the DJS person. It doesn't preclude a state's attorney from proceeding.
The victim or the victim's family should play a more, not integral role in the decision making, but do you think the input should be considered, or? I'm asking you.
Well, the bill calls for making a reasonable attempt to notify them. So again, we're talking about the misdemeanor offenses, and very infrequently do victims care about them or the nonviolence. But again, if a victim felt strongly, the victim could request the state's attorney to proceed.
Okay, I get it. So. No, I get that. So, yeah, the has made the attempt to inform the victim, but then once got it. I mean, is the victim's statement subject to consideration for the intake officer?
Well, for the
So it's subject to consideration, it's just
Got it,
not
yeah.
contingent on it.
Got it.
Thank you. you. Counsel, you referenced 14401 crimes of violence, but it's been a while since I revisited that list. Can you tell us what the 14401 crimes of violence are?
So, yeah, 14101 defines crime of violence as abduction, arson in the first degree, kidnapping, voluntary manslaughter, mayhem, maiming, murder, rape, robbery, carjacking, armed carjacking, first-degree sex offense, second-degree sex offense, the use of a firearm in the commission of a felony, except for possession with intent to distribute a CDS, child abuse in the first degree, certain sexual abuse of a minor, home invasion, human trafficking offense, an attempt to commit any of those crimes, a continuing course of abuse with a child, first-degree assault, assault with intent to murder, rape, or rob, or to commit a first or second-degree sex offense.
So what was the, so for not including, so not marrying this, like the 14101 crimes, the list we just read, with enumerating here on, what you've done on page 2 and 3, what was the policy reason? There's gotta be a policy reason why not just marrying it with 14101 as opposed to pulling out these crimes? I know there's, just can you remind us what the policy reason was? Or what the discussions looked like to develop the list, as opposed to just marrying it to 14101.
So I think that the commission didn't want to go that far to encompass all of the crimes under that. I think also there was consideration given to the very minuscule number of persons this age committing those crimes or accused of those crimes or acts that would be crimes. And then I think also, like I said before, this was based on the Sentencing Commission's determination of what are the most severe crimes. And so the desire of the commission was to focus on those most severe crimes. And the state's attorneys agreed, I just have to repeat this. This isn't like something that we pulled out of our hat. This is a 2-year process where multiple stakeholders sat around, debated these issues, and the ultimate vote was unanimous, including state's attorneys that were on the commission.
Are we just gonna keep walking through? Rest is further.
So-
Everyone's good? We'll keep walking through.
The next portion of the bill, beginning on page 8, deals with pre-hearing detention. So generally speaking, a child may be placed in detention pending a hearing in the juvenile court if either such action is required to protect the child or others, or the child is likely to leave the jurisdiction. Under current law, there are certain crimes for which a child cannot be placed in pre-hearing detention. And what this bill does is it repeals most of those specific exemptions and instead states that a child may not be placed in pre-hearing detention if the most serious offense that they're alleged to have committed would be a misdemeanor, unless it is a handgun offense or the child has been adjudicated delinquent at least twice in the prior 12 months. In addition, the intake officer and the court would be required to conduct a risk-scoring instrument before placing a child in pre-hearing detention. And on page 12 of the bills, there are some changes being made to what the responsibilities of DJS are regarding a child who's in detention. So the bill would require that within 10 days of the decision to detain a child pre-hearing, DJS would have to submit a plan to the court for releasing the child back into the community. And DJS would additionally be required to appear within 14 days to explain any reason for a continued detention and to continue to appear every 14 days after that.
Senator West.
Thank you, Mr. Chair. So as I indicated before, I was on this commission, and my concern was, which was vocalized at the time, is I didn't want kids terrorizing a neighborhood. And so the kid does something wrong, he gets arrested, pulled in, and by that night, he's back at his home again and terrorizing the neighborhood the next day, all over again. So we had to call it quits. And so that was the genesis of this provision, which I think is the key one here, that the child You can detain a child if the child has been adjudicated delinquent at least twice in the preceding 12 months. So kid gets 2 bites at the apple, and the third time, he's out. That's what this language provides. Now, I will add that Bob Casserly was suggesting adding a third provision here that says risk of harm to others, risk of flight.
Isn't that factored into the risk assessment tool?
I would assume that's right, but I'm just noting what Bob suggested.
Just because people start arguing, doesn't mean you gotta turn on my light. Oh, you good. Oh, I didn't say anything. Oh, okay. Sorry, Senator Carter.
Nothing except for it clearly states that detention decisions are based on the verified risk assessment tool, and so those considerations that Senator Casserly suggests would already be taken into consideration in the risk assessment when the court made the determination of detention or non-detention. It's a non-issue.
So the current law regarding detention is on page 8 of the bill, in lines 17 and 8, or starting on line 14 and going through line 18, which is that a child may be placed in detention prior to a hearing if such action is required to protect the child or others, or the child is likely to leave the jurisdiction of the court. And the bill would additionally add consultation with the risk scoring instrument as something that would have to happen before a decision is made on detention. Moving on, the next portion of the bill, beginning on page 12, deals with out-of-home placement, which is one of the dispositions that can occur once a child has been adjudicated delinquent. They can be placed out of the home in a DJS facility. So the bill would prohibit out-of-home placement of a child if the most serious offense that they're adjudicated guilty on would be a misdemeanor if committed by an adult, unless the offense is a firearms offense and the child has been previously adjudicated delinquent on another firearms offense, or the offense is a technical violation of probation. Moving on to the next portion of the bill, which begins on page 14. This deals with the length of probation terms that children may be sentenced to in the juvenile court. It places some limitations on those terms of probation. So if the most serious offense that the child is adjudicated delinquent on would be a misdemeanor, the court can sentence the child to an initial term of 6 months of probation, and then if the court finds that there is good cause and in order to complete a treatment or a service, the probation may be extended for up to 3 months at a time, not to exceed 1 year total. So in other words, they could extend probation for 2 3-month periods if the court made the requisite finding. If the most serious offense the child is adjudicated delinquent on would be a felony that is not punishable by life imprisonment, they can be sentenced to an initial term of 1 year of probation. And then for good cause and to complete a treatment or a service, the probation could be extended again by 3 months at a time, not to exceed 2 years total, unless the court finds by clear and convincing evidence that there is good cause and it is in the best interest of the child, in which case the probation can be extended for up to 3 years total. And finally, if the most serious offense that the child is adjudicated delinquent on would be a felony punishable by life imprisonment, the initial term of probation could be up to 2 years. And for good cause and to complete a treatment or a service, it could be extended for 3 months at a time with no upper limit on that extension. And finally, the bill would provide that a child may not be placed in pre-hearing detention for a technical violation of probation.
I mean, that's a bit absurd. A felony, talk about judicial discretion. A kid commits a felony, you're gonna put him on, the judge can only do 1 year supervision. I know they can come back. But, and then the other part Josh just read, a felony which is, what'd you say, up to life?
Yeah, felony which is punishable by life has.
Punishable by life, a judge, you're gonna cap him at 2 years? I mean, come on. This is judicial discretion. If a kid commits a felony punishable by life, we're gonna pass a law saying you put them in supervision for 2 years, they have to renew it every 3 months after that? I mean, if that happens, quite frankly, a felony, especially a felony punishable by life, a judge should just have discretion to decide how long they're gonna supervise them. That is a bridge way too far. I cannot believe that everybody signed off on that one. Senator West, were you okay with that one?
Let's do Senator Carter.
And that's a huge one. Punishable by life? You're gonna give him 2 years supervision?
Yeah, what page you on?
Page 14, what he just read off. If a juvenile commits a felony punishable by life, we're gonna come in and tell a judge they have 2 years of supervision on them. On any other felony, they get 1 year. That's a bridge way too far as judicial discretion. There are probably not a whole lot of juveniles that fit into that category.
They're not.
But the ones that do, for God's sakes, they should be under supervision. You commit a felony punishable by life, that's a serious offense. That's probably like a murder.
I'll ask.
So wait, so you murder somebody as a juvenile? We're gonna say 2 years you get supervision? That's insane.
So,
I'll Senator Carter this. Go ahead,
no, go ahead, ask.
So, you're charged as an adult, or if you're, that does not apply, does it?
It doesn't apply.
Okay.
Well,
Even if we were to pass the other bill, it wouldn't apply because those children would be most likely moved up to adult court. And we're still talking about children under this bill that are not subject to the adult court for the most part. We're talking, so a 13-year-old in current law is not going to be charged as an adult.
But
Just get Senator out.
But you have judicial discretion. You're talking about somebody that committed potentially murder here, and that we would cap supervision in any way, to
Well-
take judicial discretion in any way for somebody that committed murder for
First of all,
2
it's
years
30
supervision.
It's 36 months.
Quite frankly, if you murdered somebody as a juvenile, I feel completely comfortable with the court having you under supervision until you're an adult. I cannot believe we're gonna talk about a felony punishable by life and put a 2-year cap. We shouldn't touch that at all. That should be completely judicial discretion.
I know. And you're gonna be charged as an adult.
So there's a lot of silence here. Let me just say, Josh, first of all, we're not talking about having a large number of children under this. If a child commits a serious crime that could be a felony, they can be under the jurisdiction of the juvenile court until they're 21. A judge under this bill would be able to use probation up to 36 months, and as the amendment that we discussed that you didn't mention, a judge would, under this bill, under any crime or any act that would be considered a crime, have the ability to start the clock over again if there were any violation of the probation or if the judge found good cause, I believe. So I don't think, I know that what Senator Huff is saying sounds alarming, but in practical reality, we really aren't talking about probably anybody. Because there's not very many kids that are in there in the juvenile system for murder.
Right, so if the case
But the
proceeds,
jurisdiction of the juvenile court for that is up to the age of 21 at any rate.
right, if the case proceeds and there's a conviction in an adult court, none of this applies to that case. And if you want, I can introduce the amendment you had right now, or.
Well, but we can't operate in a vacuum, because we've got a bill coming up next that I'm trying to look at too, which deals with, for example, rape. There's some serious offenses that's gonna put them in the juvenile system. So, somebody commits a felony punishable by life, and as you just explained, 2 years, and then every 3 months, a judge has to continue it. That is a huge burden on a judge. I mean, what happened to judicial discretion in here? It works both ways. We can't just say we're against mandatory minimums, and then somebody murders somebody as a kid, and every 2 years and every 3 months, the judge has to continue it. There's a huge burden on a judge. I can't believe the judiciary signed off on this. Did they come back and was the judiciary on this commission? Did they say they were okay with this?
There was one judge on the commission, he abstained on every vote, on every single vote. So the
Well, see,
judiciary really wasn't
See,
represented.
that's not helpful, because when we did the Justice Reinvestment Act Commission, they actually voted on it.
But if I could enter this conversation, Senator Huff made the correct point, which is that there are two bills here. The second bill, which we're going to deal with in a few minutes, is where a case starts. And so I was not in favor of the final decision of the commission in that one, which is, I think, one reason why it's separated out into two bills here. So in my view, really serious cases like felonies, first-degree murder and the rest, ought to start in the adult court. And because that's where realistically where they're going to end up. And my argument was, and still is, why start them in the juvenile court when you know perfectly well they're going to end up in the adult court if they're really serious crimes? And by the same token, why would we start a misdemeanor in the adult court when we know it's going to end up being tried in the juvenile court?
Well, the other thing is that, I mean, this committee, I've tried and others have tried to keep felonies as more serious offenses. There's bills in here every year I speak against that make things felonies that should not be. And even this, if you take out the felony punishable by life, a straight up just felony, which I think we've done a decent job of keeping felonies to major crimes, that gives you, what do you say, 1 year?
The initial term could be up to 1 year, and it can be extended for 3 months at a time, not to exceed 2 years total.
Whoa, whoa, whoa. So you commit a felony, you get a max of 2 years supervision?
The court, unless the court finds by clear and convincing evidence that there is
Oh
good
my
cause and it's in the best
God.
interest of the child, then you can go up to 3 years total.
Oh, my God. No. What?
No.
In the,
The
other report.
The other bill that was,
yes.
bill that was disagreed.
Craziest thing I've ever heard.
No, I'm getting nods over here.
See if Scott Schellenberg voted for this.
Everybody voted
You commit a felony, you get a max 2 years? That's insane.
Operating
looking at the-
assumption, the operating assumption. The operating assumption of those on the commission was that juveniles accused of felonies were going to be tried in the adult court, not in the juvenile court. This entire bill is premised on the assumption that the juveniles being affected by this bill are being handled by the juvenile court.
Just pretend that doesn't exist. Pretend we don't know what's happening. Look at the offense. You're talking about a felony. In Maryland, some of us have strived to keep felonies to the most serious offenses. You know, Mr. and Mrs. Lamb, murder, rape, sodomy, larceny. Those are the most serious offenses. Why you would want a judge to only have a max of 2 years on a felony of supervision of a child? I am totally comfortable with a judge having supervision on that child till they become an adult.
Again, our operating assumption was that those
I
cases
know.
weren't going to be tried in the juvenile court.
But-
They're going to be moved up to the adult
But
court.
that's technical procedural. Look at the actual crime. A felony is a major offense under our law. And then you get a max 3 years on a felony punishable by life, a max 3 years?
Well, the initial term is 2 years, and it can be extended 3 months at a time with no upper limit on that.
No upper limit on that. But on a felony, which, last time I checked in Maryland, you commit a felony, that's a big deal. A max 2 years. That's totally unacceptable in my book.
And
Sorry, Senator West, go ahead.
Remember, if the juvenile is tried in the juvenile court, when the juvenile turns 21 years old, the juvenile walks away scot-free, which is why I believe that the felonies ought to start in the adult court, because they're going to end up there. No state's attorney in his right mind and no judge in his right mind is going to allow a juvenile to be tried in a juvenile court for a felony when the juvenile, if convicted and the juvenile turns 21, the juvenile walks away scot-free. It's not going to happen.
These are the
But we're looking,
automatic-
we're
those
on
are
this bill.
automatic charging ones.
We are
I
on this
mean,
bill.
Well, I mean, even to take it back locally, I've not seen that. When I've seen serious juvenile offenses, they've gone to the juvenile court, even in our county. I don't know what state attorneys you're talking about. They're saying these felonies are automatically end up in juvenile. That's not what I've seen. And an adult. And that's not what I've seen. We've had serious assaults we had an assault that resulted in death. They could not get in the adult system in our county. It ended up in the juvenile. A lot of these felonies are going to the juvenile. I don't know where you think, now this list here, the automatic charge, those will go into the adult. But if they're not in the automatic charge, from what I've seen, they are going into the juvenile system. Did the state's attorneys come and say that the felonies that are not on this list are going in the juvenile system? So I'm looking at a different bill. So if you go to Senate Bill 165, it shows you the automatic charges of adults.
I think it's fair to say that the state's attorneys did not support Bill 165.
The problem is, from my experience, what I've seen, if they're not on this automatic charges of adult, even if they're in a felony, they'll go into juvenile. That's where they'll go.
Right.
And so under this, if they go into the juvenile, what you're saying is they commit a felony, which is a serious offense. It's not on here. They're going to end up in juvenile. They're going to end up with a max 2 years on a felony supervision.
That's not, can I speak on that? No, it's not as if they commit a serious crime, a felony, or a murder, they would not be committed, meaning that they'd be the juvenile equivalent of prison. This is about probation. If they commit a serious crime or a murder, they're not going to be sentenced to probation. The probation is something that would happen like adult court that would most likely occur once the commitment is over. So I don't think that's a sensible thing to say, that they're going to be sentenced to 2 years. Not only that, the bill calls for possible 3 years, but what I'm saying is that, so you're 13, the rare oddity of a 13-year-old who is found delinquent of murder in the juvenile system, they're going to be committed to prison, or the equivalent of juvenile prison, and then probation would only kick in, as it does in adult court, once the prison term is over. If they ever even get probation, they may never get probation. They may just be committed until the age of 21. I think that's the more likely scenario for a murder, the very rare murder committed by a 13-year-old.
But it may not be a murder. What if it's just another felony conviction?
I mean, it's all of it. This, just because they're...
A murder's going to fall, they're going to get charged as an adult.
We're talking about limitations on probation. We are not saying it's to the exclusion in felony cases.
No. A
of
murder's going to
commitment.
get charged as an adult, but any other felony conviction, most likely, who's not on this list, is going to get charged as a juvenile. And what the bill says is, forget murder, because even under the bill and the amendments that you have here on 165, they're going to charge as an adult. But any other felony, you're capping at 2 years probation. Why? You commit a felony, I have no problem with you being in probation until you're 21. How so, if it's a 2-year cap?
You're not likely going to get sentenced. Your disposition is not likely to be probation if it's a violent or serious felony. Your disposition is going to be commitment to the department and a
All right,
placement, which is the
so-
equivalent of prison.
So you committed at 17.
That we discussed actually, when we had even though the commission all voted unanimously on these recommendations, we still decided to have additional conversations about it. And out of those conversations, we agreed to an amendment that would, I think, cure Senator Huff's problem, which is that if a court finds there's a need, Josh can speak to the language, exact language, but the court can restart the clock of probation from the beginning and start the entire thing over, and there's no limit to how many times the court can do that. So this individualizes it, so that person you're concerned about is going to be amenable to the bill as amended, and there would be no limit of the 2 years, even though my argument is that they're not going to get probation anyway for those 2 years. They're going to get a commitment to the department.
So the amendment is in your packet. It's number 553421/1, and the relevant language is at page 15, after line 26. This is at the end of this section that imposes caps on probation. And essentially, as Senator Carter explained, what it would do is say if a juvenile is under probation and they commit a violation of that probation, including a technical violation, that essentially resets the clock on all of the caps, so the court could come back after a hearing and impose a new term of probation that would be subject to the initial caps and all the caps for the underlying offense. So if they had a misdemeanor, for instance, and they'd been on probation for 5 out of the 6 months, and then they commit the violation, the court could then sentence them to a new term of probation with that initial cap of 6 months and the extensions that would apply to that. Including all the additional extensions that you could get. Basically, it would be as if you were coming in the initial,
You get another 2 years.
right?
For each violation of probation.
If that was the sentence.
No,
Just
just,
one time.
yeah, it would kind of.
Why would you want to treat it? All right, but why would you want to treat a technical the same as any other violation?
You don't.
Like, why would you restart the clock completely on 2 years on a technical, which is basically you violated a term of probation that wasn't a new crime, versus, I mean, why wouldn't you break that out either?
Let me take another crack at it. So Senator Huff is bumping up against the problem, and that is if these heinous crimes are handled in the juvenile system, and the juvenile gets to walk away on his 21st birthday, all the stuff in between, the probations and the rest, doesn't really add up to much time, because when he turns 21, he's going to walk out. That's why these heinous crimes have to get tried in the adult system, where they can be sentenced for a reasonable period, reasonable sentence, not 3.5 years of probation when you put it all together, and then he walks away when he's 21 years old.
If you're trying to do, there's a couple issues here. And I don't understand, and this is on the pro-reform side, you don't want to treat a technical violation like a brand-new violation and allow them in for a whole new 3 years on that. Why would you want to do that? A technical violation. They showed up late to their probation
There's
meeting.
no detention for a technical violation under the bill.
But what this says is that if they have a technical violation, you treat it like they allow us to start the clock all over again. You don't want to do that.
It would allow it if the court determined there was a good cause to do it. And so a technical I mean, the idea was.
So if you show up late to your probation meeting, you don't want a judge to come in and say, I'll give you a whole new 3 years.
No. Well, make an amendment to take the technical
You
out.
don't want that.
Make an amendment to take the technical out.
I wasn't in the room when you guys did this, but like, so why, I do agree, like, the technical violation, why was that included? And then second, why, at that point, since you're at the, almost like the third or fourth bite at the apple at that point in time, why not, if you're already down here where the amendment enters into the kind of the process, why not then give the judge, I'm asking, I just want to see what the discussion was like, why not then give the judge the discretion to extend the probation for however long she or he sees fit at that point in time? What was the discussion like? I'm trying to understand.
So I think that was the point, to say that the judge can start the clock over again. That's essentially saying the judge can impose whatever the judge so desires to impose by saying that the judge can restart the probation or impose whatever term. That's the intent of it. If that's not how you read it, that was the intent. So the discussion was based off of this idea that a kid will just not comply and just run the clock out of the finite probation. And so the thought was, well, if we allow the judge this extra mechanism, frankly, that I didn't think was necessary, but I thought it might appease some of the concerns that I'm hearing now. If you give the judge this extra tool, then it would ensure against, if there's a reason for the judge to extend the probation, the judge has the authority to do it. That's the reason, the rationale. There wasn't a discussion about exempting the technical violation when we talked about the amendment.
So now I'm arguing the other way on this bill, because I've been arguing max judicial discretion, but if you're going to do a reform bill, you should not allow them to come in on a technical violation and restart. We've been very firm, we've been fighting for years on the caps on the adult side, we should not, I would say you should strike a technical violation out of this.
Yeah, I agree. This is an amendment that the commission never considered. And I don't know why we would want to include the term technical violation in this new language here. In line 26 on page 15, we should take it out.
So I think just,
So the thought was, if it's a technical violation, it could come into play when it's the need to continue treatment services.
No. No. I mean, so they did that on the absconding thing, so which made sense, but a technical violation, this is so funny, because I'm literally arguing.
I got you.
I'm arguing your
First of all,
side
I'm
now.
not arguing to keep I am not arguing to keep technical in, okay? I'm just
I
explaining
mean,
what we did.
maybe you could do, okay, I'm okay with the revision if we do leaving treatment services or something like we just did on the absconding bill. But what you don't want is a kid shows up late to a probation meeting and the judge
You're
goes,
preaching to the choir,
"Bam!"
Huff. So moved, seconded.
But if there's something on treatment services like we just did on absconding, I'm okay mirroring the absconding language into this,
When the
but,
doves are flying your way, quit calling them, you got it.
well, no, I think we can fix it though, because so here's what we could do to match the juvenile system and the adult system. What I would say we could do is say, strike technical, but say a technical violation is not absconding from a drug treatment, whatever this, the same language that we just passed on the floor. So that deals with the issue if you leave a drug treatment or a facility, but you don't want to end up with the technical violations under this. That's my suggestion, so that at least our adult and juvenile system looks similar.
Okay, but by the way, absconding is already listed on page 16, which is, it's not considered a technical violation.
Well, then we're good. Then I would just strike technical in that language.
Right.
so I think, yeah, just for clarity, instead of striking technical, I think it makes more sense to simply strike including a technical violation and say excluding a technical violation. Because if you just say a violation, it implies that you may be including both technical and non-technical.
All right, so I still think that at that point in time, the judge should have the ability to extend probation for as long as they need.
You could make that amendment too.
So the way repeated the same cap as before, so it's the 2-year cap for probation, for the extension of probation. Why at this point in time did we not just say that however long that the judge deems necessary, give that judge the flexibility at that point in time? You just repeated the same cap, so you just basically start the clock all over again, essentially?
I don't know, I thought that sounded reasonable, but.
So you get Jill.
To it, like I said, I did this as an appeasement. I didn't think we needed any of it all, so I'm not wedded to it. If you would prefer to do it, to give the judge that allowance. But I think that moves us further away from the intent of the bill. We're always looking at the most horrific situation and the worst situation as opposed to the normal situation. In the normal situations, the goal of this bill was to give finite terms to probation that are meaningful to youth, that actually have an impact on their lives, because under the current situation, so many youth are on indefinite probations and lengthy probations, and they aren't meaningful, and there isn't any kind of a motivation to comply. And so this was to try to shorten it, make it finite, and ensure that it had meaning and served its purpose. That's the purpose of the bill.
put a pin in this one, though, for this.
Wanna come back to that?
Yeah, I do. We'll talk about it again. Yeah, go ahead.
Do you want me to ask about the gun stuff or not?
Are we still in the same section?
Talk about it again. I'm happy with the, amending the amendment as you suggested.
Got it. Well, you adopted amendments on amendments, so here, let's do this real quick. So that we are all working off of the same document because now if we're talking, you're gonna adopt amendments on top of conceptual amendments that are not on the bill. So, I'm gonna make a motion to adopt the amendments in the packet so that we are all just working off of this.
553421/1.
Okay, and everyone's good with that? So then the first amendment that was added on to this first amendment was how did you word it again to remove the technical violation?
So,
Excluding technical.
I think maybe except for, I think is the more proper way to say that, but same idea. So instead of saying including a technical violation, it would be except for a technical violation.
Before we go forward,
I just had a quick question for Senator West. So on page 13 of the reprint, we seem to exclude from DJS custody firearm offenses for the first time. And I don't understand what the policy rationale was behind that. That's line 14 of page 13, so I just wanted to understand
Firearm.
what the policy rationale was.
I need to go back, but let me just remind you that Senator Smith was also on this commission. It's not just Senator West. I'd have to go back and read it. Let me check it. The firearm language is an exception. So going back, I believe it says, if I'm reading it right, a child may not be committed to the Department of Juvenile Services for out-of-home placement if the most serious offense is 1, 2, 3, 4, 5, 6, 7, 8 is an offense that would be a misdemeanor if committed by an adult unless the offense involves a firearm.
And then there's an
I'm sorry, the child has been adjudicated delinquent on a prior occasion for an offense involving a firearm. Right. So what this literally says is the child gets one free firearm offense before the child can be committed, and if the child commits a second firearm offense, the child gets committed. So the child can had the alternative treatment that was discussed earlier in the bill. The child can be put on probation for the first offense. The second offense, the child can get committed.
What's the policy reason for giving everyone one free firearm offense?
I guess because he's a child, and children do dumb things.
So they bring a gun to school. You get one free gun you can bring to school? I mean, being serious.
You don't
good.
You don't get committed and taken away from your parents for doing dumb things as a child.
For bringing a 9mm loaded gun to school, you don't get
say misdemeanor.
So if the first firearm offense is a felony, that wouldn't be subject to this. But if it's a misdemeanor, then they would have to get the second one.
First one's a felony, you fall under the caps though, the bill.
Correct, but
So you bring the loaded 9mm to school, you do fall under the supervision caps.
Yes, but you would be eligible for out-of-home placement, basically to be detained at a DJS facility.
Wait, bring a firearm to school is a felony?
No.
Okay, so, all right.
It's a misdemeanor.
That's why it's an exception to the misdemeanors, because possession of a firearm is a misdemeanor offense, whether it's juvenile or it's adult. So that's why it's the exception to the otherwise misdemeanors.
So
unanimously voted on by the commission, including the state's attorney.
So one free loaded gun you can bring to school.
It's not free. They still can be subject to a sins petition. And with the goals of this bill, there wouldn't be a second time. There'd be less likely to be it because they'd actually have intervention right then and have services that they would need right then, you know, assuming that there were some that they needed.
They could not be committed to a DJS facility after they've been adjudicated delinquent.
They could be detained, but they couldn't be committed. So pretrial detention could occur.
Pretrial detention is available for
Right.
a handgun
But
offense.
commitment to, like,
Specifically a handgun offense, yes.
incarceration
Just,
post couldn't occur.
okay, just so we have this, I have this clear. You bring a loaded gun to school, you cannot be incarcerated now when we pass this.
If it is a misdemeanor offense, yes, if it is your first misdemeanor offense and you're adjudicated delinquent on it, you cannot be placed in out-of-home placement, which is, you know, essentially committed to a DJS facility
Okay,
after.
so we're saying that, okay, got it. Only on the second time you bring a loaded gun to your school can you be detained. All right, thank you.
And finally, the final portion of the bill really begins on page 18, which is, first, it establishes the Commission on Juvenile Justice Reform and Emerging and Best Practices, which would be required to produce an annual report beginning in 2023. And it also requires the Governor's Office of Crime Prevention, Youth, and Victim Services to obtain and analyze data on juveniles charged as adults and the use of juveniles, rather, the use of divergent for juveniles, and they would be reporting annually beginning in 2023. That's the end of the bill.
There's a second.
Did you want to do the thing about that?
So, for a first-time misdemeanor gun offense, a person can be detained until there's an adjudication. And at the time of an adjudication, the person could be committed to the Department of Social Services, a group home or something, taken away from his family, put in a group home, or the Department of Mental Health. If there's a mental situation, he can be committed to a mental situation. For the first time, he cannot be put in a DJS facility behind bars if this bill is passed. But for a second misdemeanor gun offense, he could.
So for bringing the loaded gun to school, I was right. That he can't be, he
Well,
can't
he
put
can be
in
detained.
DGS.
He can be detained in a facility behind bars during the detention period.
Yes, but he can't be put in a DGS facility when you bring a loaded gun to school. But also, what about a second-degree assault when you have a gun and you threaten somebody?
Well,
That's a misdemeanor, is it not?
a second-degree assault with a gun is going to be a first-degree assault. That's just point.
Serious physical injury.
Bill, just to be blunt, I'm sitting here listening. We had lots of hearing. I am just very much surprised the amount of violent offenses, the way we're dealing with them in this. Having sat through and done the whole adult system, the way that we're treating very violent offenses is very shocking to me. And we're treating firearm offenses, and we're treating felonies with life, violent assaults, kids with guns. The way that we're treating them in this, I'm a bit surprised. These are not low-level, nonviolent offenses, the way we're dealing with this bill. So in the context of the way we did the adult system and the reforms, this does not mesh with the adult system where the way we dealt with nonviolent offenders. These are ultra-violent offenders we're talking about. I know it's a small number, which I'm surprised that the committee that put this together wanted to have a fight over a handful of kids that committed very violent offenses. I guess that's the politics of today. They felt comfortable bringing this in, but to be honest, it's kind of a gas listening to Josh describe this. That's my view. So, I mean, if y'all want to vote it, I'm comfortable, fully comfortable knowing how I'm going to vote.
Senator Watson. Senator Sidnor. Senator West. Senator Hedelman. No. Senator Lee. Got anything else to say?
Has Josh finished going through the bill?
We have. Senator West.
To the sponsor of the bill, having heard the strongly voiced objections of Senator Huff, do you want to go back and consider additional amendments, or do you want to roll this the way it is?
I like to roll it the way it is, but, I mean, I haven't heard a specific amendment from Senator Huff, so that's another issue, except for the exempting the technical violations, which I agree with. I don't agree, so I don't agree with Senator Huff's point of view. I actually think this is totally in line with adult justice reinvestment. The idea is to give children the services and treatment they need without criminalizing them, without tearing them away from their homes, as you've said. And so what this bill does is it takes the lightest things and it prevents them being incarcerated. It takes the lightest things and it keeps them from being placed on lengthy probations. And then for the more serious things, it still puts them in the system. It still allows for commitment. It simply, I think, very thoughtfully meets it out. Senator Huff continues to focus on these probations as if young people that commit the most serious acts are not going to be committed. They're not going to be placed on probation. I think that's a very important distinction. So, you know, to be outraged over, a possible 2-year probation for a murder, that's just not going to happen. They're going to be committed. They're not going to be given probation. So that's what I think, it's like very alarming sounding, but it's incorrect.
So here's where I'm coming from. We really should, I think, have considered the other bill first, because the first question is, where is the juvenile going to be, where is he going to have his crime or his offense adjudicated? Is it going to be in the adult court where he could receive an adult sentence and be treated accordingly? Or is it going to be in the juvenile court? We really should have considered the other bill first. So then we would know what offenses are going to be handled by the juvenile court. And they're not going to be these heinous crimes. In my view, they shouldn't be these heinous crimes. They should be the offenses that the juvenile courts are currently handling, which is mostly misdemeanors and some minor felonies. Then with that in mind, we should have considered this bill, and our mindset would not have been dealing with heinous offenses, because this bill is all about the juvenile courts. It's not about the adult courts at all. And we would have a mindset that what we're dealing with here are misdemeanors and minor felonies, not heinous offenses. And where we went wrong, I think, this evening is in allowing ourselves to be persuaded, because we hadn't dealt with the other bill first, that what this bill is dealing with are first-degree murder and rape and things like that, which I don't believe are ever going to end up being tried in the juvenile courts.
I don't determine the order by which we consider bills, but I just want to, whatever you think of the other bill, we're still, as you've stated, talking only about the juvenile system here. There's nothing in this bill, or frankly, even in the other bill, that would prevent people that are committing the most horrible acts to be put in the adult system. So that's why I think we need to focus on the fact that this is a bill dealing with only the juvenile system. It's not our call to anticipate horror of horrors, a child that ought to be in the adult system, God forbid, is put in the juvenile system and might actually be subject to the services and treatment offered in the juvenile system. I think that this is a thoughtful bill. I think there's been some alarming things said in the committee, and I think it has a lot to do with the fact that maybe you weren't subject to the months and months, frankly, 2 years of discussion that was held by this commission that you were a part of, Senator West, and you were a part of, Senator Smith. And that was, for the most part, agreed to. And when I say for the most part, so there were some minor disagreements. Even
Firearm offenses. I mean, you've got, all right, to go through the parts where that are giving me serious heartburns, the cap on felonies, and then the cap on the life, the 2 year and the 1 year.
why do you keep on saying that?
Because it's 5 people, but it's 5 people that the judge should have complete. The judge should have complete jurisdiction over a kid that did a felony punishable by life. You'll never convince me that that should be in this bill. That has no place in this bill. That is 5 kids who are super violent, that committed terrible offenses punishable by life. No chance you'll ever convince me that has no place in this bill. A felony punishable by life, that should be out. Even felony offenses, a year, I have serious problems with those caps. And then the second part, jurisdiction, you start talking about firearm offenses, serious crimes, 14101 doesn't bring it up. The fact that the kid bringing the gun to school loaded, I'm sorry, no. That's a no-go for me. I don't want that in this bill, that stuff. What about a kid selling drugs and he's got a gun too and all kinds of stuff?
So, a couple things. I know that this is just about, I don't have the numbers in front of me like DJS might have. I'm fairly certain that children 10, 11, and 12 that are accused of these acts, the number is extraordinarily minuscule. I don't agree that we should decide that we should expand the jurisdiction to them, because I'm gonna support the work of the Juvenile Justice Reform Council.
I'm surprised they wanted to do. I
But you're
agree.
surprised,
I
but
agree.
that's what they
I agree with
decided.
you. It's like 5 or 6 kids. So why take a product to reform the system, and focus it so much around violent offenses and felonies?
I think part of another aspect to why I feel this way, and well, I'm supporting the product of the council, but when we're talking about this, we are always still talking about allegations. And allegations are not dispositions. And allegations are made all the time that are inaccurate, and there is overcharging at every level of our juvenile and criminal justice system. And so there's nothing stopping these children from getting the services that they need without being committed.
But that's a hell of a leap to go from a shoplifting charge to an armed carjacking or first-degree rape or.
Armed carjacking is already exempted.
That's true, but the rest of 14101 is not.
Mr. Chair, do you want to make a motion to add crimes of violence?
Seconded to run the bill.
Oh, to run the bill.
I think we should entertain a couple of amendments, but
Who moved to run the bill?
How about if the bill fails, then we can.
well, I don't want to.
I don't know the bill's gonna.
I mean, so the question is, if we weaken the bill, destroy the intent
I'm
of
not-
the entire Juvenile Justice Reform Council, to appease one, maybe two people, what does that mean for the bill? Because if none, we're not getting the vote anyway, I say roll the vote as it is.
It's gonna be interesting watching administration for a week. I mean, I have no vested interest in this bill, one way or the other.
Been a motion, it's been seconded. We'll pick up the motion and take a 5-minute break, and we'll pick up the motion. So there's been a motion, it's been seconded, it's been properly seconded, so we'll take it up. Okay, we'll take a 5-minute break. All right, so we've got the motion for favorable and the second has been withdrawn. I'm gonna go ahead and offer an amendment, two amendments. So for the jurisdiction on page 2 and 3, you would essentially, so on page 3, you would essentially strike from line 1 to 15 and add anything that would, if committed, would constitute what is a crime under section 14-101. Is that conceptually?
Yeah, so
Can we do? Can we give to Josh?
So basically, starting at the bottom of page 2, it would be, except as provided in subsection D of this section, who is at least 10 years old, alleged to have committed an act, 1, that if committed by an adult would constitute a crime of violence as defined under 14-101 of the criminal law article, or, and then on page 3, you'd be striking the entirety of lines 1 through 15, and it would just go on to be arising out of the same incident as an act listed in item 1.
All right, this is a motion for that amendment. It's been seconded. Everyone, okay, adopted. All right. Second amendment would be on page 13. So from lines 11 to 16, it would read, an offense that would be a misdemeanor unless, what?
So yeah, the new language, starting on line 12 would be an offense that would be a misdemeanor if committed by an adult unless the offense involves a firearm or, and then lines 14 through 16 would be struck.
It's a motion to adopt the amendment. It's been seconded. Great, adopted. All right, now the bill is before you as amended. The motion is for a favorable with amendments.
And I'll speak on it.
Sure.
I mean, those amendments are better, but you still have in here that a juvenile with that's been convicted of a crime punishable up by life still has the cap of 2 years and a 1 year under the other felonies. I realize they may or may not get it. We don't actually know that they're getting a sentence. But judicial discretion works two ways. When you oppose mandatory minimums, it should work the other way. And we're talking about serious offenses. You're talking about a juvenile that has committed a crime punishable by life. That juvenile, as far as I'm concerned, can stay in the system until they're 21. I have no need to intervene whatsoever in that. Why we would want to, and you're right, there are 2 or 3, 4 or 5 cases. Why are we getting involved in those? Why not just let a judge have discretion on those? Why get involved and put caps on them and make them come in and all that? That is a small number of the most serious offenses you could have.
No, I mean, so the discussion of the committee, I mean, with the work group was that although, yes, serious offenses, that when folks have kind of certain benchmarks, certain finite periods of time to meet goals, then folks do better. And if there's a reevaluation period at the end of that time, you can extend the cap. I mean, you could extend the period of probation.
So you murder somebody, you're already in the juvenile system, you're gonna be done at 21. And we're saying that now you get 2 years of supervision under the system? That's a heck of a light sentence for murdering somebody.
If you're in the juvenile system.
Yeah, if you're in the juvenile system, again, this is 3 people we're probably talking about.
Which probably would never fall back to the juvenile system.
May not, but let's see what we do on the next bill. But nonetheless, you commit something punishable by life. And we're saying, right now in the system, you only get up till 21. And we're going to cap the supervision you have? No. I'm a heck no on that one. The judge should have complete discretion on you until you're 21. You're in the juvenile system. You're going to walk scot-free. There's no record of anything when you walked out of there. You committed and have been convicted of a crime punishable by life. And we're going to cap supervision at 2 years? This is I cannot believe, now I know why Senator Cassidy was so upset. I cannot believe the department would not want supervision on somebody until they're 21 who could convicted of a crime punishable by life. And for God's sakes, give a judge discretion on that individual. So that is just unacceptable to me.
Any further discussion? Anyone want to offer a rejoinder? I think, look, the scenario you described is certainly possible, but highly, it's just not probable. So all the cases you described
put it in the
would
bill?
start in the adult system.
Why is it in the bill then? With all due respect, why is this in the bill? Who felt it was important to come in for life offenders and put a 2-year probation cap in? That is the most irresponsible thing I've ever heard of.
I could just, I don't want to go back and forth with it. I mean, we know who thought it was a good idea. All of the people on the commission that voted for it. We're talking about children that fall under this jurisdiction, and even Senator Huff acknowledges it's really not likely to be more than 1 or 2. I haven't heard, I mean, I'm kind of done with amendments, but I haven't heard one offered, and I would reject it if it is.
I mean, if I out for an amendment to remove people with life sentences from this bill.
I would move people too, but I wouldn't move children. So for that reason, I would reject that suggestion.
We could amend page 15 of the bill, line 19, to take out the words "not exceeding 2 years" and insert "up until the child's 21st birthday." My guess is that most of these kids are pretty close. You know, if you take 2 years, you don't have much of a gap between the end of the 2 years and the 21st birthday. But if we wanted to accommodate Senator Huff, it would be an easy change to make. Exactly, and it only applies to kids who have committed a crime punishable by life imprisonment, and not many kids fall in that category. Yes. On page 15 of the bill, lines 19 and 20, take out the words "not exceeding 2 years" and replace them with "up until the child's 21st birthday."
All right, Wes, listen to this.
So I think the best way to accomplish that, essentially what you're saying is there should be no caps at all on life crimes, correct?
To the age of jurisdiction.
And I think the cleanest way to do that is just to strike subsection E, so line 16 all the way through 26, because if you say for life crimes, you can go up until the age of 21, you kind of imply that for the other crimes, you can go beyond that. So if you just remove life crimes from the bill entirely, I think that means there would be no caps whatsoever on life crimes,
Okay.
except for the 21 cap.
Yeah, so just to the age of jurisdiction, say, you know, to your 21. Say, just make that clear. Yes. Until you're 21.
It gives complete, because currently, without these caps, the judge basically has complete discretion on the length of probation. So if you remove the caps on life crimes from the bill, life crimes would revert back to that system where the judge has total discretion until 21.
The judge could still cap it at 2 years if they chose.
Yes.
If they chose to do that.
So, Josh, you're saying that, that the other language in this bill covers the entire waterfront except life crimes?
Correct.
Okay.
There's misdemeanors and then there's felonies except. Crimes punishable by life, and then
Gotcha.
there's life crimes.
Fine. Okay.
All right. So motion to adopt the amendment's been seconded. It's been adopted. All right, motion is for favorable with amendments.
Second.
It's been seconded. We're gonna do a roll call. This is on the bill with the amendments.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Watson.
Yes.
Senator Bailey.
No.
Senator Carter.
Well, I guess it'll pass even without me, so yes.
Senator Huff.
No.
Chairman Smith.
Yes. All right, bill passes with amendments. That concludes the voting session for tonight.